Welcome to Leading Questions. I'm Megan Mah.
I'm Kayla Theeuwen.
And I'm Sydorenko, and we're lawyers at WeirFoulds. For those of you joining us for the first time, welcome. Leading Questions is a web series where we answer some of your burning questions about law, business development, and professional development.
This seemingly never-ending pandemic has caused some people to pivot career paths and are considering opening up their own businesses. Today, we're hoping to answer some of your questions about how to navigate the process of incorporating a new business.
We're joined by two of our in-house experts, Rochelle Perera and Adrian Howard, lawyers in WeirFoulds Private Equity Group. They regularly assist startups and new businesses in getting off the ground, so we're really excited to have them with us today. Hey, Rochelle and Adrian.
Hey, how are you guys?
Hey.
This first question is for Adrian. Adrian, what are some reasons that an individual might consider incorporating a corporation in Ontario?
Well, first off, a corporation is a separate entity or a separate person from an individual. And when we say that, we mean that the corporation has rights unto itself. So it can sue or be sued. It can be charged with a crime. It can enter into contracts on its own, and it pays its own taxes. And so there are certain situations where the owner might want to take advantage of having this separate entity. And one of the main ones is the fact that there is a separate corporation means that the corporation is not, the shareholder itself is not liable for the corporation's debts.
So, okay, this sounds like a structure that can be particularly helpful during stressful financial times, like this pandemic.
You're absolutely right. A corporation has debts unto itself that is separate from the assets of the shareholders and directors of the corporation. So what that means is in this kind of time where, for example, a lot of people are having trouble paying their rent as their business rent or other suppliers, they can rest assured that their creditors won't be coming after their house, their car, or their personal investments unless they explicitly agree to do so. And
okay.
to move on from that, there are some other advantages to structuring a business as a corporation. The other one is that a corporation generally has easier access to money that can be used for the business. The corporation can raise money by issuing shares. Investors, whether they're sophisticated or not, may be attracted to this kind of investment because this kind of investing is very familiar and well known. A business that is structured as a corporation may also have an easier time borrowing money to fund its operations because banks and other financial institutions tend to be more comfortable with lending to corporations rather than unincorporated businesses. On a related note, other contractors and suppliers of the corporation may just feel more comfortable dealing with a corporation rather than an unincorporated business. There's just something about that Inc. or Corp. Or Limited after the name of the corporation that tends to give people a little bit more confidence.
Okay, I see. So to summarize, by incorporating, you have less personal liability, easier and faster access to funds, better borrowing terms, and you may even gain negotiating power. Sounds like a good deal to me. If I wanted to become a shareholder of any company, does this become part of any public record?
No. So if someone wants to find out information about a corporation in Ontario, they can look up what is called the corporate profile report. The corporate profile report will give information such as the registered address, the names of the directors and officers, and the addresses that they list on file. But it will not give any information about the shareholders of the corporation, whether it be their identity or any information about them.
Got it. Okay, finally, what happens to corporations after the existing owner passes away, retires, or no longer wants to be part of the business?
Well, incorporation allows your business to continue more easily after any of its stakeholders, including shareholders, directors, or employees, retires or passes away. Because a corporation is a separate entity, it only gets wound up or dissolved at the order of a court or by voluntarily by agreement of its shareholders.
So what's the actual process for incorporating a corporation in Ontario?
So to incorporate, there's two basic steps. The first is you choose your name, and the second part is filing articles of incorporation. The articles would contain general basic information, including, the name of the company, the address of the company, the classes of shares, and, particular rights and restrictions that you want to set out for each of those authorized classes of shares.
So can I name my corporation anything I want? Are there any limits on the names?
Unfortunately, no, you can't name it whatever you want. There's two options. The first one is you choose, a numbered company. If you're stuck on a name or you prefer to use a name, there are rules that you have to comply with, including having a legal element such as Inc., Corp., or Incorporated to the end of it. And also your name can't be generally offensive, generally show that you're affiliated with any entity that you're not affiliated with, and also cannot be confusing with any other existing corporate names.
And so how long does this incorporation process last on average? Like, has the COVID pandemic kind of slowed things down in terms of registration?
So the good news is it hasn't slowed things down at all. Incorporations have typically been done electronically and continue to be done electronically. So COVID has had very little impact on processing times. Typically, you can have a corporation incorporated within, one business day, 24 hours.
So if I'm looking at incorporating a small business, like I don't expect to be the next Facebook or Amazon or anything as much as I would like to be, can I incorporate without having to hire a lawyer? Or is that something that you would recommend to kind of get some legal advice?
Well, technically speaking, you can incorporate a corporation without having a lawyer. People do it all the time. However, there may be some reasons why you may want to consult a lawyer. There are various provisions in articles of the corporation that you may want to consult your lawyer about, like what types of shares do I want to have? What types of rights do I want to set out with those shares? Are there any regulatory compliance matters for my business that I need to deal with in my articles? And then even after the articles are filed and the corporation is incorporated, you would be wise to seek a lawyer's help in organizing your business. So issuing your first shares, appointing your first directors and officers, putting together your bylaws, et cetera, et cetera.
All right, so I don't know about you guys, but I see two lawyers on the screen who you might want to give a call to if you're looking at doing this. So last question is for Rochelle. I'm thinking about incorporating with some friends. I don't really want to do this thing on my own. Anything that I should consider?
So there's kind of two things that you should mainly consider. One, if you're running your show by yourself, you're wearing all the hats, you're taking on all the obligations, responsibilities, etc. So you're going to have a lot on your plate. If you're looking, as you suggested, to lighten your load and bring on other partners, friends that can assist you, you're really putting yourself in a position where you can grow the business, share the liability, and also have the expertise of the partners that are joining you. If you choose to incorporate with one or more business partners, you just have to be mindful of the fact that you will start to lose control over at least some or parts of your business. And, there might be, you have to be wary of any potential disputes that might arise as a result of that relationship.
Okay, yeah, as you were saying that, I'm going to put my litigator hat on here for a second. How should business partners protect themselves, like just in case there might be a dispute? I know you don't want to go into a business thinking about how things will go wrong, but surely that's a risk.
Yeah, so, I always say shareholders agreement is the most useful when there is a dispute. So having a clear shareholders agreement is your best way forward. Part of what you can do to make that easier on having a dispute is clearly set out what decisions would be made and by whom and by what types of approvals. And the second part is always having a dispute resolution clause in your shareholders agreement to deal with that particular circumstance.
Yeah, so I guess that clause is going to state what law would apply and where you're going to litigate if there is a dispute. So that's helpful, something to consider. Okay, so what about some critical terms to include in the shareholders agreement, and specifically having mind to what we're going through right now and the pandemic that we're navigating?
Yeah, so I'll split that up into two answers. First, from a typical provision perspective, you'll typically set out who the directors and officers are, how a shareholder can transfer or sell their shares, and what would otherwise constitute a default. You'd also want to set out, restrictions on competing and soliciting clients, and also confirm that, all information belonging to the corporation is in fact the corporation and would be kept that way. From the COVID-19 perspective, what would be useful is having language in the shareholders agreement that allows you to have remote shareholders meetings. So you're not forced to be in a situation where you can't have a meeting without physically being present. You would adopt that same language in your bylaws. And another thing you can do is when you're allocating, who's going to sign what documents or what signatures are required to issue simple things such as checks, notes, agreements, you want to make sure that the people that you're allocating with that responsibility are in fact going to be available, so that there's no pause or disruption in your business.
So I guess the same thing would apply for board meetings too. You'd want to incorporate that, obviously not in the shareholders agreement, but you'd want to think about that as you're getting the business up and running too.
Yeah, so that would be something you definitely would put in the bylaws. Generally, the more flexibility you have, whether that be to have an electronic meeting, to have a meeting over teleconference or conference call, the better.
Okay, thanks.
Awesome. Thanks so much, Rochelle and Adrian. This was incredibly helpful and a great corporate law 101 for us as a refresh. That brings us to the end of today's episode. Thanks everyone for joining us. If you have any questions or any topics you'd like us to address in future episodes, please email us at leadingquestions@weirfoulds.com. See you next time.